Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for March 23rd, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. I'm going to just let you all know we've had several technical issues this morning with the system updating. So everything seems to be running a little bit slower than usual. If I get kicked off of Zoom, I will do my best to come back, kind of bouncing back and forth on computers. But with that said, let's get started and hopefully we won't have any glitches. Mr. Marufo, would you please call our first case?
0082 of page 1, Judge.
Okay.
Cause number 2019 DCV 0082 Ada Alicia Trujillo versus Jessica M. Enriquez Beltran et al. Announcement of counsel, please.
Joe Shelley on behalf of the plaintiff.
Raymond Bass on behalf of the defendant, Your Honor.
And good morning, gentlemen. As I looked over, I just got kicked out of Odyssey again, but I do see we're at a status hearing. Can you all give me an update, please?
Yes, Your Honor, this case is settled. I just need to get you the dismissal documents.
Mr. Shelley, is it literally just the dismissal? Have we
It
been?
is, Your Honor.
Well, let's get that dismissal in, please. I don't want to have to reset you 1 week for a dismissal.
I will get you that today, Your Honor.
Okay, otherwise it's going to be a week. Thank you very much. Thank you, gentlemen.
Thank you, Your Honor.
All right, who's next? Mr. Marufo.
Up of page 2, 3399.
Go ahead.
And cause number 2016 DCV 3399 Gloria Dominguez et al. Versus Oscar Quesada et al. Announcement of counsel, please.
Al Melendez on behalf of the plaintiff, Your Honor.
Noel Gaddis for Dr. Quesada. Good morning, Your Honor.
Morning.
Bill Wilson for Dr. Nguyen.
Keith Myers for Dr. DeLuca.
Okay, so we're at a final civil pretrial. We have our trial date set at the end of April. How are we doing?
Judge, I think we were gonna schedule it for a different date. The trial, the last time we talked, and we were trying to get mediation, and we've been working on mediation. And we're looking at August right now as far as mediation is concerned.
Okay.
And we were trying to get a number one setting because of the number of experts that required a $10,000 fee up front and cancellation 10 days ahead, stuff like that.
Have you all discussed, one of the things that is happening, I guess I haven't really thrown this out there, but you all have probably heard, we seem to be transitioning out of this COVID protocol. So that means our calendars might be opening up. We have a little more flexibility. Have you all discussed a potential date or dates for trial? Because I might be able to work with you on some dates.
No, not yet, Your Honor. We were just assuming that there were no dates available this year because we're like triple booked, most of us, I think. And so that would all depend on how the other trials go, but I think that's the issue.
So for my purposes, for this court, I have some flexibility in my calendar because the way we had been scheduling things had been guided by those panel requests, right? So I have little pockets of time, but what you're really telling me, Mr. Melendez, is that you all would rather not set a trial date until 2023. I can work with that too. So I just need to know if you all have some type of an agreement.
Let me ask counsel that are here, what do you all think? Are you okay? Do you have a preference, 2022 or 2023?
Judge, for myself, I think an early 2023 setting would be ideal. Again, given the number of experts we have and the number of parties.
Okay. Is everybody good with that? Because if you are, I just assume get you a new slate of dates with a new trial.
Agreed, Your Honor. This is for Dr. Quesada.
Okay.
Fine, Your Honor.
Okay. You'll give me just 1 second to scroll through because what you're telling me is that we're going to need this set. So even though I have a little bit of a blank canvas, I want to make sure I'm not putting you somewhere where I just happen to have another 2023 setting. All right, so I see a 0 on February 3rd, 2023. I think I'm going to go with that.
Mr. Melendez and I are specially setting the 384th on that very day, Your Honor.
So Judge Garcia beat me to it, huh? Okay. How about the 17th?
That would be fine for me.
It's fine with us.
I'm okay, Your Honor. I've got 2 other trials set, but I think also with Mr. Gaddes or Mr. Bracken, on both trials, there's 2 on the February the 20th, we start, but I'll do, does the rules allow us to bump everything else because yours is older, Judge?
What do you mean? Does the ones that you have set in these other, I mean, technically, well, no, I don't know if it's the older or the fact that it got set first. I mean, are you telling me that yours, my case is older but those are already set?
Yes, Your Honor, these are already set, but yours is the older one.
I'm not sure what the local rules, how those 2 weigh out. I would think that older goes first, but where are they set, Mr. Melendez?
That's the, let's see, the 171st. And that's with also Mr. Brackett or Mr. Gaddes. I think that's right. G. Johnson. Oh, no, that's a different, no, I apologize. No, that's a different case. And then Irma Fierro Fernandez, I think that's with Mr. Gaddes and Ms. Puig. And that's in the 171st. And the other one, yeesh, I don't remember, Judge. Well, I'm not even sure. I think they're both in the 171st.
So I'm just going to schedule it for February 17th. Okay, it's going to be a special setting. I'm going to resend a scheduling order with so we can get new dates on everything. Does anybody have a problem with that?
No, ma'am. Thank you, Your Honor.
Okay, so Myrna will need to send a new scheduling order on that one with that trial date. Alrighty. Okay, anything else?
Not on this case, Your Honor.
Okay, thank you very much. Who's
Thank you.
next, Mr. Marufo?
Hey, Judge, if I may, Mr.
Oh.
Jessup, are you here for Mr. Robles?
Are you talking about the Ibovin case?
Yes, sir.
Yes, yes. The Cliff Justice.
0935 on page 1.
Okay,
It's cause number 2019 DCB 0935. Vicky Irene Newkirk versus Margarita Arciniega et al. Announcement of council, please.
Joe Shelley on behalf of the plaintiff.
Cliff Jessup on behalf of defendant.
okay, so I just have a notation here that we didn't have a proposed order. Was somebody going to send me a proposed order on a dismissal?
I believe so, Your Honor. I don't know if that was our office or Mr. Robles's office. I'm not sure on that, Cliff. I think we signed one and sent one over with you. I'm not sure though, but we can handle that.
I know we sent one. I'm not sure if I've seen it back, but if we have it back, we can file it today, Judge. If not, I'll get with Mr. Shelley and we can get it filed today.
Okay, again, that'll be another 1 weeker. Mr. Shelley, you're going to be my 1 week reset if we don't get paperwork, okay?
I'm going to spend the rest of my afternoon doing dismissals, Your Honor.
Yay. All right, 1 week, we don't get the paperwork. Thank you, gentlemen.
Done today. Sure, Judge.
Take care. Who's next? Well, I don't know. So everybody knows we have some changes here, and I'll ask, we'll have a new bailiff starting. We're kind of in transition right now. Mr. Jose Marufo will be our new bailiff. Chuy is moving on, and we also have a new court coordinator, Ms. Myrna Hernandez, which you all would be familiar with from the 120th. So I'm going to ask if you all will put that in the chat, just if you need new emails. The court is also transitioning on an general email thing that will put out a big notice to the bar regarding our new 210th email. But for now, those are our continued points of contact for any type of things that need to be emailed and hearing requests. All right. Sorry, Mr. Marufo, Mr. Pantoja, who's next?
Okay, Judge, Mr. Shelley and Mr. Jessup are here on page 4, 2222. And I thought I had seen Mr. Raymond Baeza for, I'm not sure if he's here for Ms. Brooks.
Go ahead.
Okay, he might have stepped away, Judge. We can get back to this one. If you will stand by, gentlemen.
Mhm.
Page 2, Judge. Go ahead.
Go ahead.
1174
Okay.
and cause number 2009-1174 Dodeca LLC versus Marta Rocha. Announcement of council, please.
Yes, thank you. Charles Kennan for plaintiff, Dodeca.
And I see Miss Roche, is that you? Can you hear us? If so, if you could please unmute. So I think you either need to start, if you're using your phone, I think it's *6. *6, or if you swipe, Erica knows.
She go. Oh, no, I don't see it.
Oh, there she is. Miss Roche, I
Yes.
think okay, I lost your video, but I can hear you.
Okay.
Have you been able to hear us? Hopefully, yes.
Yes.
Okay. So, Mr. Kennan, we are here for a status hearing. Miss Roche, is there an attorney representing you, or are you here just on your own behalf?
On my behalf, but I already sent in paperwork because I settled with the company, and I sent a copy of that to Mr. Pantoja that has like the bill that I paid.
Okay, Mr. Panto, have you received any paperwork from Miss Roche? And Miss Roche, have you been in contact, or Mr. Kennan, have you been in contact with Miss Roche?
I don't believe so. No, Your Honor. This is simply our motion to revive the judgment that we obtained that originated as a Chase Bank.
Yeah, and I paid it, and I sent their. They told me that they were going to get in contact with you, when I emailed you the other few days ago, you said you hadn't heard anything, and so then I sent you a copy of the receipt.
Can you hold on a second? Can
Sure.
I ask? I'm not clear. When you're saying I sent things to you, are you referring to Mr. Kennan, or who are you?
Mr. Pantoja.
Okay, so Mr. Pantoja is the court bailiff.
Because that's the one who I was corresponding with this whole time. So when he sent me my date, then I told him that I had already settled with the company, and they're supposed to let, I guess.
Ms. Roche, let me just stop you right there. So Mr.
Sure.
Pantoja is an employee of the court, okay? And he's not the one that is going to handle or intervene in any way. We're here, the other side, the other party is represented by Mr. Charles Kennan. I don't know, if you're on your phone, you may need to scroll, because I think sometimes when you're on your phone, you cannot see everybody at the same time. But there's a gentleman, an attorney by the name of Charles Kennan. And he is on the Zoom meeting. He represents Dodeca LLC. I don't know if you're planning on hiring an attorney or representing yourself. But ultimately, if you do hire an attorney, they need to get in contact with Mr. Kennan. These matters that you're telling me, Mr. Pantoja, did you receive anything from Ms. Roche? Mr. Pantoja, hold on a second, Mr. Kennan.
I just forwarded the documents to you. She did, this was Sunday night that she forwarded a document to me. I just forwarded to you, Judge.
Okay.
I'm sorry, it was Sunday morning. No, Sunday night.
Okay, there's some type of letter here. So Ms. Roche, the court is not, we're here on a status. And I feel like this is the first time we're seeing you. I know there was a motion for substituted service previously. Ms. Roche, are you intending on hiring an attorney?
I wasn't planning to, since I paid it off.
Okay. So I think before we proceed, this is the first time the court is I guess, hearing Sunday some point from you.
Uh-huh.
Mr. Kennan, I think you need to get in contact with Ms. Roche.
Could be in time.
And I'm going to reset this status for 2 weeks. I haven't looked at your letter yet, Ms. Roche.
Okay.
Okay. Are you, what I'm going to do is I need to take down your contact information to include an email, telephone
Okay.
number, things of that nature. I don't want to do that on YouTube because we're on YouTube right now.
Sure.
Could you contact the court by phone? Do you have the court phone number?
Oh, I'm gonna get a piece of paper. Hold on, okay?
Mhm.
Okay, I'm ready.
Okay, and I always get these mixed up. It's area code 915-546.
What is it?
915.
Uh-huh.
It's 546-2130.
546-2130.
Mhm. You can speak with Miss Myrna Hernandez, and she will take down your contact information, meaning your telephone and email address.
Okay.
Okay, so we can provide a notice to you of the next hearing, which will be in 2 weeks.
Okay.
It'll be 10 a.m. on Wednesday in exactly 2 weeks, and it will be remotely as we're doing it today. So with the same login, the same way that you're logging in today.
Mm-hmm.
I just want to give you all a quick minute, the documentation that you provided to Mr. Pantoja, to the court.
Okay.
You may want to provide that to Mr. Kennan. In any event, we're going to come back in 2 weeks.
Okay. All right.
And I will send you the notice. Mr. Kennan, I'll see you in 2 weeks.
Yes, Your Honor, and I do ask, but let me state, I'd be very interested in seeing what she provided if she made arrangements to pay it off.
Right. So you all get on the get together, and then we'll see you all in 2 weeks. Okay.
Thank you. Thank you, Your Honor.
Thank you.
Thank you very much. Thank you, Mr. Kennan.
Thank you.
Yes, ma'am. Bye.
Who's next, Tree? Or Mr. Marufo?
Page 3,
Uh-huh.
3692.
Go ahead.
In cause number 2021, DCV 3692. The state of Texas, El Paso County Attorney Joanne Bernal versus Minjuan Zhang et al. Announcement of counsel, please.
Katrina Ayala for the state. The state's ready, Your Honor.
Omar Carmona on behalf of 2 of the defendants, Your Honor, ready.
Jessica Mendez, Your Honor, appointed attorney ad litem for 1 of the defendants in this case.
Good morning. We're here for a status. Can you all give me an update? Where I think we were still missing at least 1, if memory serves, and I have a feeling that hasn't changed. So
Yes, Your Honor. I'll go ahead and start. In regards to defendant Minjuan Zhang, Ms. Mendez was appointed in January in that case, or really February. We did have the opportunity to talk about the case and kind of try to get her up to speed about what was going on. I do apologize. I barely emailed her the petition and the appointment, and I think also the citation last night. I don't believe she has access yet, but I'm not sure about that to the file. We did talk. I did let her know that eventually, if Ms. Zhang was not in contact with the court or with Ms. Melendez, we'll be filing a post-answer judgment. But I believe she was asking for around 60 days to go ahead and try to make contact with her.
Mm-hmm.
And in regards to defendant Ling Feng Zhang and Sun and Dieng Long Pai, those 2 are with Mr. Carmona. I think we've waited quite a while to see if he can make contact. So I do have a post-answer judgment that I'll be filing with the court today.
Okay. Okay, Ms. Mendez, the 60 days, I don't even know if any number is going to be good enough, but I'm happy to give you 60 days. If you want to tell me 90, I'm happy to do that too. I don't know if it makes a difference, but I know this is going to be a little difficult, so.
I would prefer 60 right now, Judge. Like I mentioned, I haven't had a chance to read the pleadings other than speaking to Ms. Ayala. We did speak about it, but I think 60 days would be just to be able to get some sort of idea of how the state is going to proceed, and also if I can locate the defendant to start off with.
Absolutely. We'll start with 60. Okay, and then Mr. Carmona?
Nothing's changed, Your Honor. Same difficulty I had since the
Okay.
beginning.
Okay, all right. So Ms. Ayala, as soon as you file, then let us know via email noting, the email changes, and I don't know if I'll actually set it. I might set it. I probably will set it actually. But just get it filed and let us know when you do. Okay?
Okay.
Otherwise, we'll just have that 60-day status.
Okay, thank you, Honor.
Thank you so much. Y'all take care.
Thank you, Your Honor. May I be excused?
Yes, sir.
Thank you.
Next, Mr. Marufo.
Page 3, 2014.
Okay.
In cause number 2021, DCV 2014, David Lara versus Derek D. Cox. Announcement of council, please.
Al Melendez on behalf of Mr. Lara, Your Honor.
And Scott Mann on behalf of Dr. Cox, Your Honor.
Good morning, gentlemen. Scheduling status conference.
Good morning.
Good morning. Are you ready for a trial date a year from now in 2023, or what do you, Mr. Melendez, tell
We're
me?
ready on the 29th, Your Honor. April 29th is okay with us and Mr. Mann, I'm sure. That's why.
I'll take your
No.
first offer, Your Honor. I think we just need a trial setting. It's a med-mal case. So as Mr. Melendez told us earlier, we have to line up experts, and if we don't do it, we got to pay them.
I was going to say, I do have a request in for the 29th if anybody wants to gear up, but that's okay. We can do, let's see, we're at March. March is always tricky. You think we're going to have a real spring break next March? We'll do March 24th as the trial date, 2023. The 22nd will be the docket call. Have you all discussed, or can you agree to a mediator right off the bat, or?
Yes, Your Honor.
Who?
I think so.
Who are you
Let's
gonna
see.
use?
I always use Judge Villa, but I don't know how Scott feels.
Judge Villa is more than acceptable, Your Honor.
Beautiful. And you have a ton of time to schedule a mediation. You got lots of room. So we'll send you out the scheduling order. If you all will fill it out, get it back to us before the 2-week deadline, we'll be good to go, okay?
Yes, Your Honor.
Thank you, gentlemen.
Thank you.
All right. Who's next, Mr. Bailiff?
Page 3, 2323. In cause number 2020, DCV 2323, Oscar M. Leiva Jr. versus Miguel Lucero Jr. and Anthony et al. Announcement of council, please.
Harry Pignon for the plaintiff. Ready, Your Honor?
Morning.
Steve Wood for, Steve Wood for defendant Miguel Lucero Jr.
Ray Benavides for defendants Anthony Cordova and Viscount Properties.
Okay, and we are scheduled. Let me make sure I open up. I don't know who delivered all the documents the other day, but thank you for doing that, because I was about to go through and print. And so you saved me some effort. So thank you for doing that. Anyways, we're scheduled for a partial and no evidence summary judgment. Make sure nothing, we had a new answer. I guess I didn't see this one. Oh, that looks, no, I did. It says answer. Okay, gentlemen. You may proceed.
Your Honor, if I could maybe interrupt for a second. I just wanted to make sure that you received the response to the motion defendant's objections and motion to strike.
I believe
It was filed yesterday.
So, Your Honor, I had those documents hand delivered for you, but I did not have the latest response filed by Mr. Pignon handy at the time.
Yes, that's the one I think is missing. That's the one I think is missing, but I think are you talking about the, let me see what this one is. The one filed on the 22nd, yes?
Yes, I filed it yesterday.
So that one I did not have. That's the one I had not seen. I have it here now, Mr. Pignon, it's in Odyssey, but it was not part of the documents that I had pre-reviewed, okay? So I had seen the previous response with the supplements that I think was basically attaching that additional exhibit. So unless there's something else outstanding, that's the only one that I had not previously seen. That was filed.
Well, I filed the original, a response, a supplemental response, then a second supplemental response, and then yesterday, a response to their motion or their objections and motion to strike evidence.
Okay, so that last one is the one I had not seen. I have it here in Odyssey, as I mentioned, but I did not have that available to me. Okay, all righty. So let me make sure I haven't messed up all my printed documents here. All right. So let's get going on the summary judgment, please.
Yes, Your Honor. May it please the court, Ray Benavides here for the defendants, Anthony Cordova and Viscount Properties.
Yes, sir.
We have moved for only a partial summary judgment, Your Honor. It's a no evidence partial summary judgment. This is a November 8th, 2019 moderate impact collision involving 3 units. The court issued its discovery control plan and scheduling order that is live and controlling on October 20th, 2021. The plaintiff's expert deadline was December 24th, 2021. The case has been pending for quite some time. Written discovery consisting of disclosures, production, interrogatories, and then the pretrial filings required by the court with regard to designations have all passed. We have moved for a partial summary judgment on injury causation, Your Honor, with regard to specific damages that we believe, based on all Supreme Court and case authority, requires expert evidence. So this is a case where the plaintiff, after his accident of November 8th, 2019, gets out of the car, talks to the police officer, tells the officer he's not injured. He then later proceeds to get some, soft tissue injury treatment and sees an orthopedic surgeon who says you're released and you can go to full duty. That was Dr. Taryn Klein. But the short of it is, after propounding a number of discovery, we have received 0 expert disclosures and 0 expert designations, including within the timeline provided by the court in the docket control order. So accordingly, we moved for a no evidence summary judgment on specific damages and proximate causation of these specific damages, which is medical care and expenses in the future, physical impairment in the past and future, pain and suffering in the future, and disfigurement in the past and future. And the other part of the no evidence summary judgment is actually quite simple. This is a vicarious liability claim. Our driver was in the course and scope of employment, the defendant driver, for Viscount Properties. Viscount Properties has been added as a party defendant. We have moved for no evidence, and to clarify that, it's for no submission of the employer in the proportionate responsibility submission at the time of trial. And that's the no evidence we have, because there's no independent cause of action asserted. And so we have the supporting case law in that regard. But in response, Your Honor, and I don't know how you want to handle this, plaintiff has asserted that no experts are required in this case. And the plaintiffs filed a response and attached exhibits which we have objected to. So I don't know what order you want to hear that, whether you want to let the plaintiff provide its argument and response and its exhibits and then allow me to object, or if you want me to highlight for the court the objections.
Sure, let's start. Let's flip over to Mr. Piñon. Mr. Piñon, can you address that, please?
Address what part of it?
So the information that you provided, I believe that was the documentation from, was it Dr. Terry? No, I'm sorry. There are multiple providers that you submitted additional information on.
So if I may, Your Honor, the exhibits that the plaintiff has submitted, Exhibit 1 is the affidavit of the plaintiff himself, who is not a medical doctor or anywhere near working with any medical professional. Exhibit 2 is a desert imaging report interpreting a photograph of the spine. Exhibit number 3 is pain relief center records from a board certified pain specialist who has only been designated as a fact witness, and desert imaging is only designated as a fact witness explicitly also. Exhibit 4 is the affidavit of, no, it's the medical unauthenticated medical records of Dr. Bela Marovic, who has explicitly and expressly been designated only as a fact witness, not as an expert witness, and who plaintiff is claiming he needs no expert witness, and that all my objections should be ignored because he is not designating expert witnesses, therefore my objections are inapplicable. And Exhibit 5 is Perez Piñon's affidavit attempting himself to authenticate medical records as a custodian of the medical facility.
Hey, Mr. Piñon.
Judge, Mr. Benavides is inaccurate in many respects in what he's saying. The affidavit that I wrote is basically authenticating the records, okay, as having come from the doctor's office. That's permissible under the exceptions to the hearsay rule, 80, and I believe I quoted 8034. I'm sorry, it's acceptable under the rule for authentication. The rule for authentication 901, it has as a general authentication. It's similar to what Mr. Benavides did in attaching the documents that he's providing this court. It's saying that, hey, this came from this person. So, you know, that is sufficient in a motion for summary judgment to go on to trial. And I explained in the response that I filed yesterday, all of the law in this regard, and including that in trial, you know, we're going to be able to go ahead and present as evidence Dr. Belimirovic and or his custodian of records to authenticate the records. That is in addressing Exhibit 1 or Exhibit 4. Okay, we call him Dr. V. Dr. V's medical records. Mr. Benavides is relying on, well, he's saying that expert witnesses are required, yet he fails to address the law on the case. And he makes references throughout his arguments that expert witnesses are required. But when you look at Texas law, there's a Texas Supreme Court case that says, yeah, the general rule is you need an expert witness, but there are exceptions. And what he's asserting right now is that it's almost like all personal injury cases would require an expert witness to be able to go to trial, and that's just not true. The exceptions are outlined in this, I'm looking for right here, in my response.
Are you talking about the one you filed yesterday, Mr. Pinion?
Yes, yes. It's a Guevara versus Ferrer. And it lays out in that case, basically that non-expert evidence alone is sufficient to support a finding of a causation in limited circumstances where both the occurrence and conditions complained of are such that the general experience and common sense of laypersons are sufficient to evaluate the conditions and whether they were probably caused by the occurrence. So basically, what I'm arguing is that lay people, everybody kind of knows you get involved in a rear end accident and you can have a whiplash injury that can injure your neck and back. That's pretty much common knowledge. It's also common knowledge that these injuries can involve cervical and lumbar discs, okay? And, you know, I talked to a couple of young people yesterday, and they know that. I mean, you see it on television all the time. You see it in the internet. People go to work, they get injured. The people slip and fall, they get injured. They talk to the doctors. They know that injuries occur, and they know the kind of injuries. And what Mr. Benavides is asserting is that we need an expert witness to be able to show that my client was injured as a result of this accident. Through my client's his affidavit, we established that he suffered pain after the accident. He didn't have pain before the accident. We go through the various requirements of this, or the various, not requirements, I guess guidelines or whatever what the court of the Texas Supreme Court says. And basically you're looking at physical conditions, causation that are within the common knowledge and experience of laypersons, that they did not exist before the accident. They appeared after the accident and are within common knowledge of laypersons that this is caused. So you don't have to have experts for every personal injury case. It's just not required. What you do is you can have the medical records establish the kind of injury that occurred, the kind of injury that the plaintiff is suffering from, okay? And the plaintiff can go ahead and say, hey, this is what happened. And then the jurors look at it, well, it's common knowledge that as a result of what happened, the occurrence, and in terms of using the Texas Supreme Court's phraseology, as a result of the occurrence, these things can happen to a person. And that is what we're talking about. And he's opposing it, saying, hey, you need expert witnesses. And it's just not accurate.
Okay, let me stop right there. Mr. Benavides, what's your response to that?
Yes, Your Honor, thank you. I'm not asserting anything. I'm simply providing the court with the applicable case law. And so I have followed the court's rules and the deadlines for my filing of the summary judgment. We are here today on a trial on the merits, partial, no evidence summary judgment. And as we sit here today, Mr. Piñon, in contravention to Texas authority, is claiming he doesn't need medical expert testimony in response to this trial on the merits, my summary judgment. And although it is true, according to that Supreme Court case, Guevara, that under certain conditions based on temporal proximity, if you have a car wreck and because of the car wreck, you have a visible broken bone, Yeah, you don't need expert evidence to say you sustained a broken bone because of the car accident, because that broken bone happened immediately after the car accident. In Guevara, the occupant, the passenger in the claimant unit, sustained injury and died soon thereafter at the hospital. And actually, the Supreme Court didn't say what Mr. Piñon says. The Supreme Court specifically says, regarding this 86-year-old man, that the total of medical expenses and evidence was required to, the expert evidence was required to prove causation, and that the plaintiff required competent summary judgment evidence of causation, and that otherwise, unless otherwise some other competent summary judgment evidence is provided. In this case, if the plaintiff sustained a hand fracture because of the accident, then yeah, plaintiff can proceed to say, I had a hand fracture because of this accident. Temporal proximity is, I didn't have a broken hand the day before, and then because of this accident, I had, a broken hand. But Guevara specifically says, in matters that require expert knowledge, you are required to produce, and especially with medical causation, injury causation, you are required to provide expert evidence. And this goes back to their previous opinion in Burroughs versus Welcome, in 1995 Texas Supreme Court opinion. And this provides the kind of specificity that this court is receiving guidance from the Supreme Court that completely contradicts Mr. Piñon's opinions, which I have to object to his attempted testimony that is not supported by a single Supreme Court case authority. So the Supreme Court case of Burroughs says the following: lay testimony is not sufficient to establish a causal connection between medical problems that occur either months or even years afterwards. The case holds that when injuries such as multiple herniations, cervical radiculitis, and lumbar radiculopathy and surgical recommendations are alleged to be caused approximately by an incident, expert testimony is required because this is not within the common knowledge of a lay person. Okay, so here, it says the court further states causation of plaintiff's injuries such as multiple disc herniations, lumbar radiculopathy, cervical radiculopathy, and surgical recommendations are not within the knowledge of a layperson. Billing and medical records that have been submitted by Mr. Piñon without more are also insufficient to establish the causal connection. Medical records alone do not establish causation. And 18001 and 902 Texas Rule of Evidence records is not sufficient. And by the way, I know Mr. Piñon mentioned 901, but it's 902. My affidavit simply authenticated written discovery and an email to Mr. Piñon. I'm not attempting as a medical provider or owner of a medical facility to authenticate any medical records, which is required under Rule 902. So in this case, let's see what Mr. Piñon is claiming in his exhibits, Your Honor. He is claiming on behalf of the plaintiff that his neck and back pain have never resolved because of the incident, and through a pain relief specialist, Dr. Argawal, he is required to undergo ESI injections. But he wants to claim this. Dr. Argawal is only identified as a fact witness, expressly only as a fact witness. And so what plaintiff wants to do is do hearsay within hearsay. He wants to, the plaintiff himself, a non-medical expert, wants to testify about what a pain specialist says he needs with regard to ESI objections. ESI injections, according to the Supreme Court, is not something within the common knowledge of a layperson. The other thing that plaintiff states is that he saw Dr. Velimirovic, a neurosurgeon. That's not a layperson.
I'm losing volume for some reason.
A neurosurgeon.
Hold on, Mr. Benavides. Mr. Piñon, can you check? Sometimes the internet.
I can't hear anything.
can you hear us, Mr. Piñon?
Hello?
We're still on, sir.
Yeah, Mr. Piñon, can you hear us?
Okay, well, we're on, sir. Maybe you need to
So
mess with some things.
Steve,
Yeah.
can you hear us, Steve?
Yeah, let me see if we can message him. Maybe he can log out and log back.
Yeah, I can hear you guys fine.
If he doesn't check the chat, it looks like he's looking at it. Okay, so we'll just take a quick break.
Yes, Your Honor. Thank you.
Well, hopefully he can do it quickly. We don't necessarily need to get off of YouTube. Just keep going. We sure do have quite a few more. Did Mr. Lopez show up on, I'm sorry, we're waiting for Mr. Piñon. Did Mr. Lopez show up on, wasn't he substituted in on Mr. Hedeke's case? Oh, is that you, Mr. Hirsch?
Yes, Judge.
Mr. Hedeke, are you there?
I am here, Your Honor. Thought I saw Michael Hirsch was here. I think he's from Mr. Lopez's office.
And
But
Mr.
I don't see, yeah, there he is.
Mr. Benavides and Mr. Wood, if you'll just hold on, we don't see Mr. Piñon just yet. I'm going to quickly call this case. Erica, if you're there, if we can shift gears, calling cause number 2011-2614, Casco Investments, Inc. versus Robert Hool. May I have announcements, please?
Robert Hedeke on behalf of the plaintiff, Robert Hull, Your Honor.
Morning, Judge Michael Hirsch, on behalf of Mr. Lopez for the defendant, Mr. Casillas.
Okay, we were scheduled for a motion for continuance. Okay, there's Mr. Piñon. Basically, Mr. Hirsch, Mr. Lopez had substituted in, I believe, for Mr. Ellis, and this case has been pending for quite a while. And so Mr. Hedeke had apprised the court of that, but we had not formally seen Mr. Lopez enter. Basically, I needed to know if you all had any opposition to any type of continuance, and to know if you all had discussed some type of timetable for a trial setting.
No opposition, Judge. And as far as discussion on a trial setting, I don't know.
Okay. So I'm going to give you 30 days to come back on a status hearing. The continuance is granted. Myrna, for our purposes, I'm not looking at the case right now in Odyssey, but if we have any other settings outside of the 30 days, please cancel those. We'll just go to a 30-day status.
Yes, ma'am.
Thank you very much. Thank you, Mr. Hedeke. Thank you, Mr. Hirsch.
Thank you,
Mr.
Your Honor.
Piñon,
Appreciate it.
Thank you. Sorry, I was just trying to take care of a few of these while Mr. Piñon, can you hear us now? And would you unmute just so I can make sure you can hear us? Mr. Piñon, can you hear me? Yeah, I think we've lost Mr. Piñon's audio. Mr. Piñon? Okay. Mr. Piñon? Looks like we've lost him. Okay.
You might be able to call in, Your Honor. I've had that happen when the audio goes out on computer speakers. If they use the call-in feature, they can use the phone for the audio, just as an idea.
Thank you. Sorry, I'm trying to do like 5,000 things in the chat, and this is not going to be workable because obviously I don't know at what point he cut out as you were speaking, Mr. Benavides.
Yes.
And just in terms of time. I'll tell you all this. I don't know what your schedules look like. I'm happy to try and come back maybe at 2 o'clock if we want to continue this, but I know that may not be workable and he can't hear me. I'm just gonna ask him to please call the court.
I'll do that. If that's what the court wants, I'll do that.
Please call counsel for continue at 2 p.m. Hopefully we can try and do that. If schedules are not workable, what I will say is, and unless you all are requesting it, I may just go inlet. I think I have everything now, meaning Mr. Piñon's last pleading, but let's see if we can't get a conversation happening about resuming this hearing at 2 p.m. Okay?
Thank you, Your Honor.
I hope he's seen those. I can't even tell if he doesn't respond to the chat.
He has an external speaker and he says he does. So I'm feeling like that he can read yours.
We're going to continue this at 2 p.m. Oh, did you get it?
I still can't hear anything.
Well, I can hear you. Can you hear us? Yeah, no. We're going to continue this at 2 p.m.
How do I connect my phone? I see a message saying,
Mr.
please
Piñon,
call
can you hear
counsel for
me?
continuing at 2 p.m. Are you talking about me calling Mr. Benavides?
Mr. Piñon, can you hear me?
He can't hear you,
He
man.
can't hear me.
But I'm telling him going to continue at 2 p.m. We can hear him.
Yeah, well, I'm going to mute him because he's going to keep talking. Mr. Benavides, Mr. Wood, if you can, please coordinate and we'll see you all at 2 p.m.
Yes, Your
Will do,
Honor.
Your Honor. Thank you.
Thank you very much. My apologies on that.
No, not a problem. Thank you, Your
In a
Honor.
few days of technical issues. And let's go to the next case, Mr. Marufo.
Page 4, top of page 4, 2222.
Okay.
In cause number 2021, DCV 2222, Jorge Abel Ibañez versus Brian Keith Montgomery et al. Announcement of counsel, please.
Joe Shelley on behalf of the plaintiff.
Cliff Jessup, on behalf of defendant Montgomery.
Lynn Brooks on behalf of defendant Farmers.
Good morning. I almost said good afternoon. Scheduling status conference. Folks, can we just look at a trial date in 2023 or what are you all wanting to do?
That's fine, Judge.
Okay. So we'll also do, we'll do March 3rd, 2023. We'll get you the scheduling order, docket call. If you all will agree to a mediator, please, and then get that scheduling order returned to us.
Will do, Judge.
Thank you very much. Y'all are
Thank you.
excused if you don't have anything else.
Thank you.
Mr. Marufo?
Page 4, 0749, Judge.
Okay, let's get started on that one. Actually, that is going to be probably a little bit longer here. Miss Ibarra, who are you here on?
It's a Renteria, Your Honor. That is 2020 DCV 0643 with Mr. Miranda. I'm not sure if anyone's here from his office or not. I wasn't sure.
Judge,
Yes, sir.
we called Mr. Miranda's office. They did not have us on the schedule. Mr. Miranda is in surgery today.
Oh, okay.
Oh, that explains why had been contacting him. The last we had talked about was asking the court for a continuance of the trial setting. And weren't sure if the court wanted us to file an official motion or if an oral motion was going to be sufficient for the court.
So let's get a written motion. However, if you all have already discussed it and it's agreed, let's get that on file. And I'm assuming we probably have a future setting. That'll trigger me to look at it and look at dates. Okay.
Perfect. Yeah, that's where we left off, was just what dates. And then that's the response I was waiting for, but I figured we would just talk about it this morning. But that explains why that was where we left off. So
Ms. Ibarra, if you'll go ahead and take care of that, get it to the court, please. Thank you very
no
much.
problem. Thank you. Thank you, Your Honor. Might be excused.
Yes, ma'am.
Okay, good. Thank you, Judge. Bye-bye.
Let's also call the one on bottom of page 3, if that has not been.
3433.
Yes, sir.
In cause number 2019, DCV 3433, Ramos Hermanos USA Inc. versus Cargo Transportation Solutions. Announcement on council, please.
Morning, Judge Michael Hirsch on behalf of defendants, Cargo Transport.
Is anyone here on behalf of Ramos Hermanos Inc.? Let me double check something. We are scheduled for a DWAP hearing today.
It comes back to possibly Mr. Meyer's office, but they won't be able to confirm.
Judge,
Yes, sir.
we called the number on our docket and it goes to Myers Law Firm. They couldn't confirm if they were representing the plaintiff.
Judge, on this one, you granted the motion to withdraw.
Withdraw. Yes, it was Mr.
Mundell.
Mr. Mundell. And I said I would give him a small window to see if anybody showed up for the hearing. I can't actually remember if the actual client, I remember this one. Okay, so we received no other communication from anyone on behalf of Ramos Hermanos. Is that correct? All right. So this is scheduled for dismissal. No one appearing on behalf of plaintiff. Cause number ending 3433 will be dismissed for want of prosecution. Okay. And do we have anyone on 2185?
Thank you, Judge. May I be excused?
Yes, Mr. Hirsch, thank you for being here.
Thank you. You all have a great day. Stay safe.
Oh, that is, sorry, Ms. Ferris, I didn't see the rest of your last name. Okay, calling cause number 2021 DCV 2185 Discover Bank versus Daniel Martinez. May I have announcements, please?
This is Lauren Ferris on behalf of the Heston Law Firm for the defendant.
Okay, do we show anyone having received or opened notice on behalf of Discover Bank?
I need to check, but it might take a few minutes because e-file is super slow.
Okay, that's kind of how this day is going. Did we get a read receipt back, Chewy, on the Zoom invite?
No, ma'am.
And there's no one in the waiting room, Judge, either.
Okay, let me see, 2185. Give me 1 second. So we sent this out on the 16th, is that right? Order of courts. Okay, we're gonna set this for dismissal in 30 days, okay?
Okay, Judge, thank you.
Yes, ma'am.
May I be excused?
Yes, Ms. Ferris, thank you very much.
Thank you. Bye-bye.
Okay, now I think we can, who's user? Now we can get to that next summary judgment hearing with Mr. Skipworth and Mr. Darnell.
In cause number 2020 DCV 0749, Beacon Information and Technology and Staffing Services Inc. versus Antonio Maruga et al. Announcement of council, please.
Robert Skipworth, Your Honor, on behalf of Beacon Information Technology and Staffing Services.
Good morning.
Good morning, Your Honor. Eric Darnell on behalf of the defendant, Mr. Murguia, and present and ready to proceed.
Okay, we're scheduled on defendant's no evidence motion for summary judgment. I am seeing a couple of filings from yesterday. Let me see what these are. So it's defendant's reply. Oh, Lord. Okay.
Yes, Judge.
Are these duplicate documents or they're separate? Okay. All right, so I can just tell you right now, Mr. Darnell, these I have not reviewed, but you may proceed on your motion.
Thank you, Your Honor. Judge, we have the motion for no evidence summary judgment was filed, and a response was due from the plaintiffs in December, and they have failed to file a response, and they didn't file a response until last week. That's at least 90 days past date. So also we have a motion for entry of a no evidence summary judgment by default because of their failure to timely respond, and we're asking the court, since it's unopposed, basically the plaintiffs are agreeing to it and are not opposing it, so we'd ask for the entry of a no evidence summary judgment by default. And those are the two motions that we have pending today, Judge. And we also have some issues, I guess, in reference to what you were pointing out, Judge. I'm sorry. It's just that we had filed a reply to their alleged response to the no evidence motion for summary judgment, and I can get into that. But specifically, it relates and that we're asking the court to dismiss it and to strike the answer because of its tardiness, and also because it raises issues in violation of HIPAA, and we need to address that at some point in time. But we're asking for the court to strike the so-called response to our motion for no evidence summary judgment.
Okay. I haven't reviewed the, if that's the substance of, if there's not more on the argument with respect to plaintiff's response, is that all you have on the response, Mr. Darnell, on plaintiff's response?
Oh, well, I mean, I guess the rules and the law doesn't require that the court shouldn't have to go through point by point and determine whether or not it's sufficient. The same issues that we raised were not addressed in the response, and they haven't been addressed. And this case has gone on forever, and it's basically the plaintiff's way to try and, I guess, bypass or avoid having to follow the rules of procedure. The discovery deadline was 60 days ago at least, and now they're trying to bring in all this evidence that's still not sufficient to establish that they have a case and doesn't comply with what we have claimed are the deficiencies. And so for that reason, that they still haven't provided any evidence in response to our no evidence motion for summary judgment. And anything that they would have provided, I will take the next step in anticipation of the responses, is that they have failed to provide anything within the scope of the scheduling order because the discovery has passed and this was just filed, and now they're trying to introduce and bring up evidence that's not applicable, and it's certainly not evidence in a sense that it overcomes the no evidence motion for summary judgment.
All right, thank you, Mr. Darnell. Mr. Skipworth? You had a response filed on the 16th, if you could briefly.
I did, and go through the procedural problems here that the court granted the motion for continuance on the hearing on the motion for summary judgment, and we just reset it to today, and I filed my response a week before. Yes, the evidence is, now we have pled that Mr. Murguia has breached his fiduciary duty to his employer. And the evidence established by the response is that Mr. Murguia set up while he was employed by Beacon in 2015, he set up his own company to compete directly with Beacon, doing the same work. Mm-hmm. Then Mr. Murguia starts using the phone number that he essentially has appropriated or did appropriate from Beacon to catch and trap business he was director of construction. And as director of construction, he would receive proprietary information pricing, that type of stuff, and who the customers were. And as so as the director of construction for Beacon, which he admits in a letter that's attached to the response.
Judge, I'm going to object. I don't know if Mr. Skipworth is testifying, but I'm going to object. I mean, that's beyond the scope of what's required to go through and for the court to consider. And what he's testifying to, or allegedly testifying, he's not a witness.
Overruled. You may continue, Mr. Skipworth.
Yeah, what I'm trying to do, I want to point out, this man was stealing from Beacon. He was stealing customers. He stole the phone number. There was a hearing in front of a court that required him to return the phone number to Beacon. And that was, and some of this evidence was in there, and Mr. Darnell was present at that hearing. And and there is a case from El Paso, Salas versus Airtech, directly in point, where an employee who sets up its own company to compete with his employer is in breach of his fiduciary duty to his employer. And that's what we're alleging. And in addition to, there's fraud. Mr. Murguia comes to his employer and tells him that he wants to take care of his daughter. So he's going to be off. And so he wants to use the phone number, which he did. He took the phone number and used it to intercept phone calls. And then at one point was telling his employer, well, she asked him, where is the business? We aren't competing on, we aren't bidding on anything. Oh, we don't have any business. There is no business. While he has set up his own competing company and is taking and making all the bids on the business under his new company. And this is long before he leaves the employment of Beacon, which he finally left in, actually just never returned in, I think, September 2016. But during that period of time, he was able to steal this business and use that information in order to compete directly with his employer, which is a breach of his fiduciary duty. And his representations were fraudulent, that he wanted to use the phone number while he's off on leave or medical leave for his daughter. So that's where we're coming from. And the damages we estimate to be about $250,000.
Give me 1 second, please. Ms. Rios, I'm not sure now if I'm clicking on the wrong. Are the two documents that were filed that are show up in Odyssey on yesterday, showing up filed yesterday?
Yes, those were duplicates.
They are
I didn't
duplicates,
notice
right?
until this morning.
Yeah.
Yep.
Okay. I thought when I opened one, I saw one that had a different number of pages, but I think I'm just getting cross out here with Odyssey. So they are duplicates. Okay. So then I think I've
Your audio is kind of cutting out, Judge, when you were saying whatever last sentence.
okay.
Your eyes were crossing, I don't know.
Yeah, my eyes are crossing on Odyssey, clicking on all these different documents here. Okay, so, you know, I'm trying, as you all are speaking, to look over this last filed pleading, which is why I was looking at both, because I thought there were two, but it's just one, Mr. Darnell. Your reply to a well, it's got a long title, I'll say that. I do want to look it over a little more thoroughly. Do you have anything else for me, Mr. Darnell?
Sorry, Judge, I had it on mute. Just that I guess the axiom is that if somebody can make up inflammatory enough facts that aren't supported and but have no damages, that it's going to be persuasive, and that I think that's definitely the case here. And there's no evidence to support it. And here we are. This is the first time any of this evidence has been introduced. And the end of discovery was in January. So it's obviously just an attempt to circumvent the rules of civil procedure and put us in a position where we can't defend our case. But that being said, I mean, that's our situation. And we still have some issues that dealing with the disclosure of privileged and confidential and private health information that was in the referenced response, which was late, which was due in December. But anyway, I guess that's all we have at this time, Judge, unless you have specific questions.
No, I'm going to review your final pleading. You'll have an answer on the summary judgment and what other requests? I'm trying to see what all is in your final reply. You're asking for pleading, do the inclusion. All right, that's it.
We'd ask it be struck. That was it. And then that we had submitted the order on the non-suit. The court had asked us to submit an order. I apologize. We, since it was a notice, wasn't sure some courts require an order and some don't. And I think you had requested specifically an order, so we'd submitted that.
Judge, on that point, I prepared the order on the non-suit, sent it to Mr. Darnell for his approval. He has not approved it, so I sent it to you for signature today. The Supreme Court, I think, indicates that an order is required to make sure that the non-suit goes through. And then I also want to point out to you that if the court denies the motion for summary judgment, which I think you'll have to do based on the evidence that I've produced, we have a motion to compel discovery. Because of the facts of the case, we're going to have to get into much information from Murguia concerning his business and that what's the business he stole from his employer. And I want to get over this hump of the discovery. I mean, I get a bunch of responses to discovery or interrogatories that are nothing but dribble. They're just objections. That's all they are. And that gives me no information. If we keep going like this and going like this, we'll never get this case finished.
I understand.
Judge, if I may reply, just if you want to see dribble, I'll be glad to provide you with responses for requests for disclosure from the plaintiffs, with as inflammatory as all the other representations that have been made today by plaintiffs' counsel. But I know you have lots of other better things to do. But.
And he's claiming in his pleadings to you that he never received the responses to the disclosures, and now he's just saying that he did get them. So, which I can prove. We sent them to him 5 times.
Thank you, gentlemen. I'll have you a response on the summary judgment, certainly by the end of the week, but we're here very shortly, okay?
Thank you, Judge. May we be excused?
You may. Thank you for your time.
Thank you, Your Honor. May I be excused too?
Yes, please. Thank you. Who is user 01? That person keeps coming on. Okay.